The ruling by the 5 judges was more than 100 pages and was read for nearly 3 hours. Yet at the end of it all, it was victory for the IEBC and nothing to smile about for the opposition. 2 main issues had been brought before the judges, one by NASA and the other the main appeal by IEBC. On the matter of public participation, the judges say that since IEBC had sourced Ghurair printing and publishing through a direct procurement, it was not mandated to engage the public. The judges ruled that the numerous methods of procurement cascade from open procurement to direct procurement. If the tender had been awarded through open procurement, then the public would have been engaged.
There is no constitutional or statutory mandatory requirement that there must be public participation before a decision to adapt or use direct procurement is made. Direct procurement cannot be unconstitutional.
The judges said that conducting public participation when awarding a direct tender beats the purpose because direct procurement is only used in exceptional circumstances, and IEBC had demonstrated that this was an exceptional circumstance. The court also dismissed assertions by Ghurair that his rights had been infringed on because he had not been informed on who had been awarded the tender to print the presidential election ballot papers. They also insisted that public interest must triumph because directing the IEBC to conduct public participation had the potential of delaying elections which would lead to a constitutional crisis.
We find that the High Court in this matter exercises discretion wrongly without regard to the constitutional timelines within which presidential and general elections is to be held vis-a-vis timelines for various procurement activities.
The second matter was NASA's persistence that there was a link between the Ghurair printing and publishing company and the president and other people in the executive. The judges argued that the newspaper cuttings that NASA had presented in court as evidence were not enough to prove that there was a connection between the president and managers of Ghurair.
We find that the High Court in this matter exercises discretion wrongly without regard to the constitutional timelines within which presidential and general elections is to be held vis-a-vis timelines for various procurement activities.
The ruling now means that Ghurair can now proceed to print the presidential ballot papers, unless of course there is an appeal. Ghurair, whose argument of public participation had won the day in the High Court, says he supports the decision of the Court of Appeal and will not be moving further.
We welcome the decision of the Court of Appeal and we abide with the decision of the learned judges.
NASA, however, is not happy with the ruling and questioned some sections of it.
We have to sit with our principals. We are just the lawyers, so we have to advise on the situation as it is, which they will consider in respect of the political situation, and they will make a decision where they would want this to go.
The judgment is a relief to the IEBC, which would have been forced to probably start a fresh tendering process as it looks for a company to print the presidential ballot papers. All eyes, however, now will be on NASA to see whether they accept the ruling or they appeal it in the Supreme Court. Andrew Ochieng, NTV.